A natural law theory is a critical reflective account of the constitutive aspects of the well-being and fulfillment of human persons and the communities they form. Such a theory will propose to identify principles of right action, moral principles, specifying the first and most general norm of morality or principle of morality, namely that one should choose and act in ways that are compatible with a will toward integral human fulfillment. Now, among these principles are respect for rights people possess simply by virtue of their humanity, rights which, as a matter of justice, others are bound to respect, and governments are bound not only to respect, but to the extent possible to protect. Now, natural law theorists of my particular ilk understand human fulfillment, the human good, as variegated. You notice I mentioned the various aspects of human well-being and fulfillment. There are many irreducible aspects of human well-being. That is, purposes or ends that are fulfilling, inherently enriching, worthwhile for their own sakes, not reducible to each other or to some common factor. Now, this is not to deny that human nature is determinate. Obviously, anyone who is a natural law theorist believes that there's a determinate human nature. In fact, anybody who's sensible believes there's a determinate human nature. Anybody who's observed other human beings or reflected on his own life knows that. It's to affirm that our nature, though determinate, is complex. We are animals, but rational. Our integral good includes our bodily well-being, to be sure, but also our intellectual, moral, and spiritual well-being. We are individuals. We come packaged that way. But friendship and sociability are constitutive aspects of our flourishing. So in ways that are highly relevant to moral reflection and judgment, man truly is a social animal. Well, by reflecting on the goods of human nature, especially those pertaining most immediately to social and political life, natural law theorists propose to arrive at a sound understanding of principles of justice, including those principles we call natural rights. In light of what I've already said about how natural law theorists understand human nature and the human good, it should be no surprise to learn that natural law theorists typically reject both strict individualism on the one side and collectivism on the other. Strict or radical individualism overlooks the intrinsic value of human sociability and tends mistakenly to view human beings atomistically. Collectivism compromises the dignity of human beings by tending to instrumentalize and subordinate them and their well-being to interests of larger collectivities, social units. Ultimately, the most extreme case of that, of course, is the totalitarian Nazi or communist utopia. Now, individualists and collectivists both have theories of justice and human rights, interesting ones. There are strong traditions on both sides of thought about justice and human rights. But as I see it, both end up with unsatisfactory accounts of justice and rights. They are rooted in important misunderstandings of human nature and the human good. Neither can do justice to the concept of a human person. That is, a rational animal who is a locus of intrinsic value and is such an end in himself, who may never legitimately be treated as a mere means to others' ends, but whose well-being intrinsically includes relationships with others and memberships in communities, beginning with the family, in which he or she has, as a matter of justice, both rights and responsibilities. So I think the common failing, as radically different as they are between collectivists and individualists, is a failure to understand properly and in its richness what a human person is, what it means to be a person, a locus of intrinsic value, but one who is fulfilled by, among other things, relationships with others and membership in communities. Now, natural rights, human rights, exist if it's the case that there are principles of practical reason directing us to act or abstain from acting in certain ways out of respect for the well-being and dignity of persons whose legitimate interests may be affected by what we do. Now, I certainly believe that there are such principles. They cannot be overridden by utility, considerations of utility. At a very general level, these principles direct us, in Kant's famous phrase, to treat humanity always as an end and never as a means only. Remember that formulation of the categorical imperative? Treat humanity, whether in the person of oneself or another, treat human beings, including oneself, always as an end and never as a means only. Now, when we begin to specify this general norm, We identify important negative duties, such as the duty to refrain from enslaving people. Now, although we need not put the matter in terms of rights, we can speak a different language. The language of rights is not essential, it seems to me. It's perfectly reasonable and, I believe, helpful to speak of a right against, for example, being enslaved, or to speak of slavery as a violation of natural rights. The right against being enslaved is a right people have not by virtue of being members of a certain race or class or sex or ethnic group, but simply by virtue of our humanity, our status as persons, rational animals. In that sense, it's a human right. Human right. But there are, in addition to negative duties and their corresponding rights, certain positive duties. And these too can be articulated and discussed in the language of rights, though here it's especially important that we be clear about by whom and how a given right is to be honored, if indeed it is a right. Sometimes it's said, for example, that education or health care is a human right. Now, it's not unreasonable to speak in this way, but much more needs to be said if it is to be a meaningful statement. Who is supposed to provide education or health care to whom? Why should those persons or institutions be the providers? What place should the provision of education or health care occupy on the list of social and political priorities? Is it better for education and health care to be provided by governments under socialized systems or by private providers in markets? These questions go beyond the application of moral principles. They require, in addition to moral premises, prudential judgment in light of contingent circumstances people face in a given society at a given point in time. And often there is not a single uniquely correct answer. The answer to each question can lead to further questions, and the problems can be extremely complex, far more complex than the issue of slavery, where once a right has been identified, its universality and the basic terms of its application are fairly clear. Everybody has a moral right not to be enslaved, and everybody has an obligation as a matter of strict justice to refrain from enslaving others. Governments have a moral obligation to respect and protect the right against being enslaved, and correspondingly to enforce the obligation. Now, what I've said thus far will give you a pretty good idea of how I think we ought to go about identifying what are natural rights or human rights. But in each case, the argument must be made, and in many cases there are complexities to the argument. One basic human right that almost all natural law theorists would say belongs in the complete set of human rights, natural rights, is the right of an innocent person not to be directly killed or maimed. This is a right that's violated when someone makes the death or injury of another person the precise object of his chosen action. It's the right that grounds the norm against targeting non-combatants, even in justified wars, and against abortion, euthanasia, the killing of hostages, and so forth. Now, of course, in the case of abortion, some people argue that human beings in the embryonic or fetal stages of development do not yet qualify as persons, and so do not possess human rights, do not yet possess human rights. And in the case of euthanasia, some argue that permanently comatose or severely retarded or demented people do not or no longer qualify as rights bearers. Now, I think these claims are gravely mistaken, but I won't here go into my reasons for holding that the moral status of a human being does not depend on his or her age or size or stage of development or condition of dependency. I presented this argument in great detail in numerous places, as has Hadley and others. My own latest example is in my co-authored book, Embryo, A Defense of Human Life. Here I'll say only that people who do not share with me the conviction that human beings in the early stages of development and in severely debilitated conditions are rights bearers may nevertheless agree that whoever qualifies as a person is protected by the norm against direct killing of the innocent. Now, the natural law understanding of human rights or natural rights I'm here sketching is connected with a particular account of human dignity. Under that account, the natural human capacities for reason and freedom are fundamental to the dignity of human beings, the dignity that is protected by rights, fundamental rights. The basic goods of human nature are the goods of a rational creature, a creature who, unless impaired or prevented from doing so, naturally develops and exercises capacities for deliberation, judgment, and choice, even when we're babies or fetuses or embryos, we have the root, radical capacity for characteristically human activity. We will, by a self-directed process, unless impeded from doing so or prevented from doing so, develop the immediately exercisable capacity for rationality. And even if we, through a genetic defect, are mentally and severely retarded, so that there's a block to our fully exercising, in an immediate sense, characteristically human mental capabilities, the block is a defect in us as the kind of creature we are. If the defect could be corrected by a genetic manipulation or by a miracle, it wouldn't change the individual from being one kind of thing into another. It would perfect the individual as the kind of thing he is, that is, a rational animal. In any event, these capacities, which I see as at the core of the idea of human dignity, are godlike capacities, albeit, of course, in a limited way. In fact, from the theological vantage point, these capacities for reason, deliberation, judgment, constitute a certain sharing, limited to be sure but real, in divine power. This is what is meant, I believe, by the otherwise extraordinarily puzzling biblical teaching that man is made in the very image and likeness of God. After all, I mean, it can't be the case that we're made in the image and likeness of God in the sense that God has 5 fingers on each of 2 hands or has a nose or ears. No, it's not that. What is godlike about us? Well, I would submit, I'd follow Aquinas on this, that it's our powers of reason and freedom, the powers to envisage states of affairs that do not exist, to understand that bringing this or that state of affairs into existence would be something that there's a point to doing, that's intelligibly worth pursuing, and acting on freedom and reason and not simply by instinct or impulse like a brute animal to bring that state of affairs into existence. The sort of power that God presented in the Bible, in Genesis, exercises. But whether or not one recognizes biblical authority or even believes in a personal God, it's true that human beings possess powers traditionally ascribed to divinity, namely the power to be an uncaused causing. Just what I described, the power to envisage a possible state of affairs that doesn't exist, and then to be able to bring that state of affairs into being by choice, acting on one's rational understanding of the point of bringing that state of affairs into being. Now, the state of affairs may be anything from the development of an intellectual skill or the attainment of an item of knowledge to the creation or critical appreciation of a work of art to the establishment of marital communion. Its moral or cultural significance may be great or far more commonly comparatively minor. The kinds of capacities that we exercise when we exercise our practical reason, when we act on principles of natural law, are not powers or capacities that we exercise rarely and only on great occasions. We're doing it all the time. We're acting intelligibly all the time. Our actions are traceable, our practical reason, the practical reason informing our actions is traceable to purposes that are intelligible. We see the point of doing and therefore do all the time. What matters for the point I'm now making is that our choices are products of human reason and freedom. They are the fruit of deliberation, judgment, and indeed choice. They're choices. We may, if we like, consider as a further matter whether beings capable of exercising such powers could exist apart from a divine source and ground of their being. But I don't think it makes sense to deny that beings whose nature is to develop and exercise such powers are lacking in dignity and human rights and may therefore be treated as mere objects or instruments or property. So you don't have to be a theist in order to understand that human beings, oneself and others, really do possess, by their natures, powers, capacities that are traditionally of the sort ascribed to divinity, that evoke awe, literally awesome powers, awe-inspiring powers, the power to be an uncaused causing. Now, what about the authority for this view of human nature, the human good, human dignity, and human rights? Well, natural law theorists, of course, are interested in the intelligible reasons people have for their choices and actions. we're particularly interested in reasons that can be identified without appeal to any authority apart from the authority of reason itself. Now, this isn't to deny that it's often reasonable to submit to and be bound by religious or secular, for example, legal authority in deciding what to do and not do. Indeed, many natural law theorists have made important contributions to understanding just why and how people can sometimes be morally bound to submit to and be guided in their actions by authority of various types. And think of the work of Yves Simone, for example, or Elizabeth Anscombe on authority. But even here, the special concern of natural law theorists is with the reasons people have for recognizing and honoring claims to authority. We do not simply appeal to authority to justify authority. If you look at Simone's writings, if you look at Anscombe's writings on the subject, you see that what they're fundamentally about is identifying valid reasons for submitting to authority. One might then ask whether human beings are in fact rational in anything more than an instrumental sense. Can we, as I'm assuming we can and asserting we can, discern any truly intelligible reasons for human choices and actions? Now, the question is whether some ends or purposes are intelligible as providing more than merely instrumental reasons for acting. Are there intrinsic, in other words, as well as instrumental goods? Skeptics deny that there are intelligible ends or purposes that make possible rationally motivated action. They believe that all of our actions are ultimately motivated by subrational or non-rational motivating factors: feeling, desire, emotion. Reason's role is purely instrumental to enable us to discern how to realize or achieve ends that are given not by reason or understood not by reason, but are given by emotion, feeling, or some other non-rational motivating factor. Natural law theorists, by contrast, hold that friendship, knowledge, critical aesthetic appreciation, and certain other ends or purposes are intrinsically valuable and make possible truly rationally motivated action. These are ends or purposes that are intelligibly choice-worthy, not simply as means to other ends, but as ends in themselves. They cannot be reduced to, nor can their intelligible appeal be accounted for exclusively in terms of emotion, feeling, desire, or any other subrational motivating factor. In fact, we would make the argument that in many cases, not all, but in many cases, our desire or the feeling that makes us want to do a certain act or achieve a certain goal is itself the product of our intelligent grasp of the intelligible good to be realized in the contemplated action. So these basic human goods are constitutive aspects of the well-being and fulfillment of human persons and the communities they form, and they thereby provide the foundations of moral judgments, including our judgments pertaining to justice and human rights. Now, of course, there are plenty of people today who embrace philosophical or ideological doctrines that deny the human capacities I maintain are at the heart of human dignity. They adopt a purely instrumental view of rationality, an essentially non-cognitist view of practical reason. Hume's view, as he famously put it, that reason is and ought only to be the slave of the passions and may pretend to no office other than to serve and obey them. That sums up the basic skeptical position. Sure, we're creatures possessing reason, but our reason goes only so far down. It cannot identify what to want, only how to get what we happen to want. Reason is freedom's slave. Freedom's ingenious. Reason is passion's slave. Emotion's ingenious servant. Here Hume was being very faithful to his great predecessor Hobbes. Remember that line from Hobbes that the thoughts are to the desires as scouts and spies to range abroad and find the way to the thing desired? The mind, the thoughts, are to the desires as scouts and spies. It's to figure out how to get what is wanted. Can't adjudicate among possible. Can't adjudicate between Mother Teresa and Hitler as to what our ultimate goals should be. They're just given. Mother Teresa is given, just a matter of brute fact. She's given the desire to save the dying people in India or to bring comfort to them. Hitler is just given the desire to push Jews into gas chambers. Reason can't adjudicate among those ultimate objectives, but it can explain, it can help Mother Teresa understand how to be more efficient in bringing care and comfort to people, and explained to Hitler how to be more efficient in getting more Jews into gas chambers. Truly rationally motivated action for the Hobbesian Humean types is simply impossible for creatures like us. It's an illusion. We think we do it. We experience ourselves as doing it, but we're not actually doing it. The real account of what we're doing is not one that attends to the ultimate reasons for our actions, because there are no ultimate reasons for our actions. The real account identifies the emotional basis of our actions, all of our actions. So on this account, there are no more than merely instrumental reasons for action, no basic human goods. Now, if proponents of this non-cognitivist and subjectivist view of human action are right, then it seems to me that the entire business of ethics is a charade, and human dignity is just a myth, just a superstition. But I don't think they are right. Indeed, I don't think that they can give any account of the norms of rationality to which they must themselves appeal in making the case against reason and freedom that is consistent with the denial that people are capable of more than merely instrumental rationality and true freedom of choice. I've made this argument against a very capable contemporary Humean with whom I have debated the question, Geoffrey Goldsworthy, who's an Australian philosopher, in the second chapter of my book, first or second chapter of my book, In Defense of Natural Law. I won't go into it here. The point I'll make here is I don't deny that emotion figures in human action, all human action. This is not a view that says all that's going on in human action is reason. No, emotion obviously does, and on many occasions, it or other subrational factors does the main work of motivation. You're thirsty, you get a drink. You're angry, you yell at your kid. But I maintain that people can have, and often do have, basic reasons for their actions, reasons provided by ends they understand as humanly fulfilling, worthwhile, and desire precisely as such. And these ends, too, figure in motivation. I mean, think of what brings us together for this institute or for this luncheon today. It's the desire, yes, to enhance our understanding of some important issues in political philosophy, American history. But behind that desire, I suggest, that desire is not brute. Behind it is an understanding of the inherent worth, the possibilities of fulfillment that one finds in understanding, intellectual knowledge, moving from a situation of relative ignorance or intellectual weakness to a position of greater knowledge, intellectual strength, even wisdom. Now, if I and other natural law theorists are correct in affirming that human reason can identify natural rights as genuine grounds of obligation to others, how can we explain or understand widespread failures to recognize and respect human rights and other moral principles? Well, as human beings, we are rational animals, but we are, of course, imperfectly rational. We all know that from our own experience. We are prone to making intellectual and moral mistakes, and we're capable of behaving unreasonably, sometimes grossly unreasonably, especially when deflected by powerful emotion that runs contrary to the demands of reasonableness. Even when following our consciences, as we are morally bound to do, we can go wrong. A conscientious judgment may nevertheless be an erroneous one. Some of the greatest thinkers who ever lived failed to recognize the basic natural right or human right to religious liberty. Their failure, I believe, was rooted in a set of intellectual errors about what such a right presupposes and entails. The people who made these errors were neither fools nor knaves. The errors were not obvious, and it was only with a great deal of reflection and debate that the matter was clarified. Of course, sometimes people can fail to recognize and respect basic rights because they have self-interested motives for doing so. In most cases of exploitation, for example, the fundamental failing is moral, not intellectual. In some cases, though, intellectual and moral failings are closely connected. Selfishness, prejudice, partisanship, vanity, avarice, lust, ill will, and other moral delinquencies can, in ways that are sometimes quite subtle, impede sound moral judgments, including judgments about people's rights. Whole cultures or subcultures can be infected with moral failings, failings that blind large numbers of people in those cultures or subcultures to the truth about morality or justice or human rights. And ideologies hostile to these truths will almost always be both causes and effects of these failings. Consider, for example, the case of slavery, again, in the antebellum American South. The ideology of white supremacy was both a cause of many people's blindness to the wickedness of slavery and an effect of the exploitation and degradation of its victims. Let me now turn to the question of God and religious faith in natural law theory. Most, but not all, natural law theorists are theists, religious believers, believers in a personal God. They believe that the moral order, like every other order in human experience, is what it is because God creates and sustains it as such. In accounting for the intelligibility of the created order, they infer the existence of a free and creative intelligence, a personal God. Indeed, they typically argue that God's creative free choice provides the only ultimately satisfactory account of the existence of the intelligibilities humans grasp in every domain of inquiry. Now, natural law theorists do not deny that God can reveal moral truths, and most of us believe that God has chosen to reveal a great many such truths. However, natural law theorists also affirm that many moral truths, including some that are also revealed, can be grasped by ethical reflection even apart from revelation. They assert with St. Paul that there is a law written on the hearts, even of the Gentiles who did not have the law of Moses, a law the knowledge of which is sufficient for moral accountability. So the basic norms against murder and theft, for example, though revealed in the Decalogue, are knowable even apart from God's revelation, we suppose. The natural law can be known by us, and we can conform our conduct to its terms by virtue of the natural human capacities for deliberation, judgment, and choice, those capacities that represent, as I argued, a certain sharing in divine power. The absence of a divine source of the natural law would be a puzzling thing, just as the absence of a divine source of any and every other intelligible order in human experience would be a puzzling thing. An atheist's puzzlement might well cause him to reconsider the idea that there is no divine source of the order we perceive and understand in the universe. But it's far less likely to cause someone to conclude that our perception is illusory and that our understanding is a sham, though that is certainly logically possible. The question then arises, can natural law, assuming that there are truly principles of natural law, provide the basis for widely shared understandings of justice and rights without consensus on the existence and nature of God or the role of God in human affairs? Well, in my view, anyone who acknowledges the human capacities for reason and freedom has good grounds for affirming human dignity and basic human rights. These grounds remain in place whether or not one adverts to the question, is there a divine source of the moral order whose tenets we discern in inquiry regarding natural law and natural rights? Now, I myself happen to think the answer to this question is yes, I'm a theist, and that we should be open to the possibility that God has revealed himself in ways that reinforce and supplement what we can know by unaided reason. But we do not need agreement on the answer so long as we agree about the truths that give rise to the question, namely that human beings, possessing the godlike, awe-inspiring, literally awesome powers of reason and freedom, are bearers of a profound dignity that is protected by certain basic rights. My colleague here at Princeton, Jeff Stout, is an atheist, but he affirms human dignity and human rights on precisely the same ground I affirm them. He says, look, although I don't believe there's a God, I do believe that human beings exercise these profound godlike powers, and that those are sufficient to serve as grounds for me and others to recognize the dignity and human rights, the dignity and rights of human beings. And that does not seem to me to be an irrational position. Now, the next step would be, I would say to Jeff, have said to Jeff, well, how do you think it could be the case that there are creatures constituted with those literally godlike powers? I mean, my proposition is that there's an intelligible, divine source of those powers. There's a ground of our being as human beings, as rational, truly rational animals. He would give a different account. It couldn't be a purely materialist one, but it needn't, he says, and I agree, be a theistic one. Now, I think the argument for theism is better than the argument against it, so he and I disagree about that. But that argument is quite independent of the question whether human beings, by virtue of possessing these powers, possess and share a profound, inherent, and equal dignity. It's sometimes regarded as an embarrassment to natural law thinking that some of the great ancient and medieval figures in the natural law tradition failed to recognize and indeed have even denied human rights that are affirmed by contemporary natural law theorists and even regarded as fundamental. Consider again the example of religious liberty. This right was not widely acknowledged in the past and was even denied by some prominent natural law theorists. They believed, wrongly I think, that a wide conception or robust conception of liberty in matters of faith presupposed religious indifferentism or even relativism, or entailed that religious vows were immoral or non-binding because they were trying to bind the free mind, the free conscience. Or they believed in the comprehensive, or they thought that religious freedom entailed the comprehensive subservience of ecclesial communities to the state. Now, it's interesting that when the Catholic Church put itself on record firmly in support of the robust conception of religious liberty in the document Dignitatis Humanae of the Second Vatican Council, the Church Fathers presented the Council Fathers presented both a natural law argument and an argument from specifically theological sources. If you look at the document Dignitatis Humanae, you see the first half is an argument purely from natural law, no appeal to specifically religious sources, to the Bible or the tradition of the church or anything else. The second half provides a theological argument to buttress the natural law argument in the first half. Now, the natural law argument is founded on the idea that everyone has an obligation to pursue the truth about religious matters and to live in conformity with his conscientious judgments. This obligation is in turn rooted in the proposition that religion, considered as conscientious truth-seeking regarding the ultimate sources of meaning and value, is a crucial dimension of human well-being and fulfillment. It's one of those aspects, fundamental constitutive aspects of human well-being, human flourishing, whose integral directiveness entails the moral norms by which we ought to govern our lives. It's among the basic human goods that provide rational motivation for our choosing. The right to religious liberty then follows from the dignity of man as a conscientious truth seeker. Not only someone who happens to want to know the truth about religious matters, but someone who has an obligation to pursue the truth about religious matters and to live in line with the truth as best he understands it. Now, this right to religious freedom and other human rights are denied and attacked today from various quarters, and in many parts of the world, of course, they are routinely violated. The ideological justification for their denial and violation can be religious or secular. In some parts of the world, religious freedom and other basic human rights are denied in the name of theological truth. In other parts of the world, the threat comes from secularist ideologies. Where secularist ideologies are liberal in form, it is often claims to an overarching right to autonomy that are asserted to justify choices. Choices, actions, and policies that natural law theorists believe are unjust and undermine the common good. The argument is sometimes made in terms of equality as well. If the natural law view of these matters is correct, then it is moral failings conspiring with intellectual errors that sustain ideologies that compromise human rights. In a certain sense, the failings are at opposite poles. Yet from a natural law vantage point, partisans of the competing ideologies make valid criticisms of each other. Radical Islamists, for example, harshly condemn the decadent features of cultures in which an ideology of expressive and or possessive individualism flourishes. And we've all now heard these criticisms of the decadence of the West from Osama bin Laden and other radical Islamists who seize upon them as partial justifications for their jihad against us. On the other side, expressive individualists denounce the subjugation of women and the oppression of religious dissenters where fundamentalist Islam holds sway. As natural law theorists see it, threats to human dignity and human rights exist because all of us as human beings are imperfectly reasonable and imperfectly moral, as I've said. We can go off the rails. But at the same time, hope exists because we really do possess the capacities for reasonableness and virtue. Truth, including moral truth, is accessible to us and has its own splendor and powerful appeal. Of course, we will never, in this vale of tears, grasp the truth completely or live up to it in a way that is entirely free from errors. But just as we made progress by abolishing the evil of slavery, great cost, by ending legally sanctioned segregation, by recognizing finally, fully, robustly the right to religious freedom, by turning away from the eugenics policies that were once favored by so many respectable people, although those seem to be coming back into fashion by the same kind of respectable people. Natural law theorists hope that we can make progress and reverse declines in other areas. Now, of course, people who reject the natural law understanding of human dignity and natural rights will differ from natural law theorists on questions of what constitutes progress and decline. From an Islamist point of view, the types of religious freedom defended by natural law theorists will be regarded as licensing heresy and religious irresponsibility. Natural law ideas will be seen as just rhetorically toned down forms of Western secular liberalism. By contrast, from a liberal secularist point of view, natural law ideas about abortion, sexuality, and other hot-button moral issues will be regarded as intolerant and oppressive, a philosophically gussied up form of religious fundamentalism. You've all heard that accusation hurled against folks like Hadley and me by folks like Andrew Sullivan and so forth. Lee Silver. In the end, though, natural law ideas like Islamist or liberal secularist ideas will have to stand or fall on their own merits. Name-calling is just not going to do anybody any good at getting to the truth of anything. Anyone who wonders whether they are sound or unsound will have to consider the arguments offered for their support and the counter-arguments advanced by their critics. Let me say a word now about how natural law theories are both like and unlike utilitarian and other consequentialist approaches to morality on the one hand, and Kantian or so-called deontological approaches on the other. Like utilitarian approaches, and unlike Kantian ones, natural law theories are fundamentally concerned with human well-being and fulfillment, and indeed take basic human goods as the starting points of ethical reflection. Unlike utilitarian approaches, however, natural lawyers understand the basic forms of human good as they figure in options for morally significant choosing as incommensurable in ways that render senseless the utilitarian strategy of choosing the option that overall and in the long run promises to conduce to the net best proportion of benefit to harm, however benefit and harm may be defined by the particular advocate of this or that form of consequentialism. Natural law theorists share the Kantian rejection of all these aggregative accounts of morality, accounts that regard achievement of sufficiently good consequences or the avoidance of sufficiently bad ones as justifying choices that would be excluded by application of moral principles in ordinary circumstances. We just don't think there is any such thing as the greatest good for the greatest number. Unlike Kantians, however, natural law thinkers do not believe that moral norms can be identified and justified apart from a consideration of the integral directiveness of the principles of practical reason directing human choice and action towards what is humanly fulfilling and away from what is contrary to human well-being, the substantive human good. Practical reasoning, then, for the natural law thinker, is reasoning about both the right and the good, and the two are connected. The content of the human good, the constitutive aspects of human well-being and fulfillment, those ends or purposes providing more than merely instrumental reasons for action, those goods that are intrinsically fulfilling to human beings. The content of the human good shapes moral norms inasmuch as such norms are entailments of the basic aspects of human well-being considered integrally. I'll conclude with one more proposition stressed by natural law theorists, namely the fact, or in any event what we take to be the fact, that our choices and actions not only alter states of affairs in the world external to us, but they also at the same time determine and constitute ourselves as choosers and actors, for better or worse, as persons with a certain sort of character. This is the fundamental insight of Aristotle on the question of virtue. Recognition of this self-shaping or intransitive quality of morally significant choosing leads to a focus in the natural law tradition on virtues as habits born of upright choosing that orient and dispose us to further upright choosing, especially in the face of temptations to behave immorally. Now, people sometimes ask, is natural law about rules or virtues? I have a lot of trouble being patient with that question. Isn't the answer obvious? It's about both. A complete theory of natural law identifies norms for distinguishing right from wrong, norms that cannot be done without, virtues by themselves can't replace. A complete theory of natural law identifies norms for distinguishing right from wrong, as well as identifies habits or traits of character whose cultivation disposes people to choose in conformity with the norms, and thus compatibly with what we might call, borrowing another phrase from Kant, a good will, a will toward integral human fulfillment. Thank you.